application to operate a temporary special event within a general industrial use building. This is an appeal from the decision of the Development Authority granting the application. Speaking for the appellant today, we have, bear with me here, David Robinson, and then counsel for appellant number 2, Riley Snyder, also Ren Moodley and Sandra Legier may also want to speak on behalf of the appellant. Then we also have Curtis Nickel speaking in opposition to the development, and Gershan Matharu. Speaking for the city today, we have Cindy Louie, Michael Gunther, and Harry Luke. And then the respondent, we have Bruce Reith, Gary Corzan. The Subdivision and Development Appeal Board is comprised of citizen volunteers appointed by City Council, but we operate independently from City Council and all city departments. Within certain legislative limits, we have the authority to confirm, revoke, or vary the decision of the Development Authority. Let me introduce the panel to you. Today we have Mr. Jones, Ms. Monroe, Mr. Badinsky, Mr. Peterson, and I am Mr. Handa. If any of the affected parties feel that any member of this panel may have a conflict of interest, or that the panel is not capable of giving a fair and unbiased hearing in accordance with the rules of fundamental justice, please state your objections now. Thank you, Mr. Gunther. Seeing no objections, we'll let the record reflect that there were none. I'll outline the procedure for us today. After the board officer has read the appeal into the record, we will hear the appellant's presentations and any other affected parties that wish to speak in support of the appeal. Each of these presentations will be followed by questions. We will then hear from the city, which will again be followed by questions, and then we will hear from the respondent, again followed by questions. Finally, the appellants and only the appellants will be given an opportunity for rebuttal, but that's only to address information that came to light during the respondent's presentation or the city's presentation, not an opportunity to restate your case or enter into new evidence, or we'll have to go through the whole process again. Once all presentations have been made, the board will deliberate in private and render its decision in writing in 15 days' time. The board is required to make its decision based on the evidence presented, and you may see board members looking at materials on their desks, and that's just to follow along with you as you make your presentations. Madam Board Officer, can we read the matter into the record?
Thank you, Mr. Chairman. This is file SDAB D23002, an application to operate a temporary special event within a general industrial use building with accessory, professional, financial, and office support services, and to construct interior alterations from December 15th, 2022 to April 30th, 2023, located at 7011 Gerard Road. Mr. Chairman, we received documents from the appellants, from the Development Authority, and from the respondent, as well as from members of the public. Thank you.
Thank you, Madam Board Officer. Mr. Robinson, will invite you forward at this time. Just up here. Sir, the floor is yours to make your presentation.
Good morning, Council. I reside at the building at 7105 Gerard Road, and I understand that the homelessness is an issue in the city of Edmonton. You know, with income costs rising and you know, in the wake of COVID and everything else, it's been a difficult few years. At my building, currently we've had to add cameras, we've had to add lights. We put a fence up, and due to the fact that there are no people in that area at night, it's a target for some crime. I feel that, you know, adding the Mission Hope shelter would increase crime in the area and potentially, you know, costs of increased insurance costs and that sort of thing. So I think we should maybe look at somewhere else. That's all I've got. Thank you.
Thank you, Mr. Robinson. I'll see if there's any questions for you. None. Seeing no questions, I thank you for your presentation. You may resume your seat in the back there. And at this time, then we'll invite forward Mr. Snyder. And Mr. Snyder, if you want to bring your client up with you as well, you're welcome to do so. So, Mr. Snyder, we'll give you some liberty with respect to how you want to present. If your co-counsel or your client want to speak at any point, we'll give you the freedom to do as you see fit.
Thank you. No, I think okay. Thank you. Good morning, everyone. As has already been said, I'm Riley Snyder with Whitten LLP. Next to me is also my partner, Ren Moodley of Whitten LLP. We are counsel for Pure Canadian Gaming Corp. And next to Mr. Moodley is Ms. Legere of Pure Canadian Gaming Corp. She is the VP of Human Resources. Of course, we're here. Oh, sure. We're, of course, here today appealing the permit approval for the temporary shelter. And what we have provided previously or yesterday was a written submission in addition to the notice of appeal filed by Pure Canadian Gaming Corp. And I'm not sure if everyone's had the opportunity to review that or has copies in front of them, but I do have a few additional hard copies if anyone would like that. Now, what can be found in those written submissions is, of course, the reasons Pure Canadian Gaming Corp is opposing the permit approval. There are a number of tabs with documents referenced throughout these submissions, one of which is a witness statement which was sworn by Ms. Legere that has a number of documents which are relevant, including actually photos of the site and actually an overhead Google image showing the close proximity between my client's property, which is directly across the road, probably less than 60 meters across a minor road where their casino is located. And that's found at the witness statement's at tab 3. The photos are at exhibits A and B of that witness statement, if anyone would like to turn to it and take a look. I have 3 extra.
Does any of the board like a hard copy? He does have them. Yeah. Thank you. Yeah.
Now, the permit and proposed development.
Sorry.
So for the benefit of the board, excuse me, I've got a bout of laryngitis, so I apologize in advance. But as Mr. Snyder referenced, tab 3, which is the witness statement of Ms. Legere, sworn on January 4th, 2023. And we'd ask the board in first instance to refer to Exhibit B of that witness statement, which is the overhead Google Map picture that Mr. Snyder was referring to a moment ago that demonstrates the close proximity between the neighboring and affected properties. Of course, the Pure Canadian Gaming Casino being north of Gerard Road, with the Hope Mission property being south of Gerard Road. Thank you.
Now, of course, as I was saying, the permit is obviously relevant to Pure as they are directly across the street with their casino, very large parking lot. They've been there for about 25 years, have approximately 350 employees from that location. Customer or performers, AGLC employees, customers coming and going at all hours of the day. The casino is one of the few businesses in the area that actually provides amenities, which is obviously it's a largely an industrial location with industrial businesses. So it is very relevant to the location and an attractive portion of that area. Now, for some brief background about how Pure learned about the permit approval, it wasn't until about December 15th when our office, at which time a notice of property owner was provided to Pure. It was dated December 13th, and it provided notice of that the permit had already been approved and had been appealed by a third party. As Ms. Leisure's witness statement describes, Pure knew nothing about it prior to that, which is obviously surprising because they're right across the street. Now, that said, when that took place, immediately we contacted the SDAB, got some more information about the appeal, learned we could provide our written submissions by the 4th, and also took steps to file or submit Pure's own notice of appeal, which is also contained in the written submissions. So what we're seeking today is that the permit approval be overturned or revoked, the permit be denied, and that a stop work order be issued for any construction that's already been undertaken under that permit. And the reasons for this are set out in the brief, and I'll go through it a bit today, not reading verbatim for the brief, of course, but highlighting some of the key points which generally fall under 3 categories that I'll get into. First, dealing with the special event designation. Second, the zoning in the area where, of course, the shelter is intended to be, which is an industrial location. And thirdly, the undue. What we would submit is going to be undue and material interference with the amenities in the area, as well as the use, enjoyment, and value of the neighboring properties, including Pure's. Now, first starting with the special event designation, and this is in the brief or the written submissions at about pages 6 to 8. We go through this. The permit was approved, of course, as a temporary shelter in a medium industrial zone, which is interesting and concerning for a few reasons. First, temporary shelters aren't permitted or discretionary uses under the relevant section of the bylaws, under section 420 for industrial zones. And that makes sense. It's a temporary shelter, it's not industrial. What's more concerning is that temporary shelter services, as well as supportive housing, are already defined in the bylaws elsewhere. They're already permitted uses under separate zones for good reason. It's housing. They're defined under section 7.3 and 7, or 7.3.10 and 7.38 of the bylaws for residential related uses, not industrial. Now, what we submit has been done here is there's been a strained interpretation and application of the bylaws of the Municipal Government Act in order to vary the definitional aspect of a special event, which is, of course, a temporary activity occurring for a limited duration. And it's been a strained interpretation in order to fit what essentially is a square peg, being a temporary shelter, into a round hole, which is the industrial zone, where it wouldn't otherwise fit. Now, what we submit is the temporary shelter is not a special event, as would be found under the bylaws. And what we can do is look to section 91.3 of the bylaws, which deals with the exceptional circumstances where a temporary special event extends beyond the 45-day period. And what you find in section 91.3 of the bylaws is that it takes into account a siting of an event, location, size of structures such as signs, use of outdoor speakers and amplification systems. This isn't housing. These are events as you'd expect. Festivals, temporary things like that where you set up speakers, amplification, you get a permit to have that festival, and then you're gone within a few days, a week, in this case up to 45 days, not housing for 4.5 months. Now, what happens when a defined term such as temporary shelter services or supportive housing, which is found elsewhere within the bylaws for certain zones, is taken and inserted and tried to fit into this special event definition and varied, is effectively they lose all meaning. It undermines the purpose and intent of the bylaws in separating those zones, separating those definitions. If they intended temporary shelters to go in an industrial zone, it'd be a permitted use, like temporary storage is. It's not in this case.
It's not a permitted use under section 4420 or a discretionary use. It's not, sorry, it's not a permitted or discretionary use under section 420 for an IM medium industrial zone.
Now, even if a temporary shelter was a special event, we'd submit it should be limited to what the special events provide for, the 45-day period, not 4.5 months, not for an influx of 160 beds in individuals, 45 days, maybe 50 beds. Maybe in that case, but that's not what we're saying. We're saying no matter, regardless, it doesn't fit within the definition. And for those reasons, we'd submit the permit can't be approved under special event designation. Now, turning away from that and to the zoning aspect, which I've already briefly touched on the face of this, temporary shelter is not zoned, not designated to be zoned within the industrial zoning. Now, there's exceptions provided in the MGA, Municipal Government Act, and the bylaws described as section 640, sub 6 of the Municipal Government Act, section 11.3 of the bylaws. This is described in paragraphs 24 of the written submissions, where if a development doesn't comply with the land use bylaw, it can only be approved as a Class B discretionary development, which was done in this case, if one, it conforms with the prescribed use for that land in the bylaw, which for the reasons we've already described, it doesn't in this case, so it should fail on that aspect alone. It's an industrial zone, as described in the bylaws at 420.1. It's for manufacturing, processing, assembly, distribution, service, and repair uses that carry out a portion of their operation outdoors or require outdoor storage. And that's not what a temporary shelter is. It doesn't conform to an industrial use, and it doesn't really add any value to the neighborhood. Rather, as you've already heard from Mr. Robinson, it may actually detract. Now, this conformity aspect is also one of the aspects the board needs to determine on this appeal under section 687 sub 3 of the Municipal Government Act to confirm or reject the permit approval. Now, moving to the second aspect of the provisions I've just described, the second part of that test, in order for that Class B exception to apply, is what I'll call and we've described in the written submissions as the negative effect test. Does the development, or would it, unduly or materially interfere with the amenities in the neighborhood or the use, enjoyment, or value of the neighboring lands? Now, a key aspect of this is the test is, would it have these effects? Of course, we can't prove something that hasn't come to pass yet, it's in the future. But what we do have is logical reasons for the concerns Pure has raised in Ms. Leger's witness statement in its written submission as to why the development would have these negative effects. Now, the development offers written submissions, they opine it wouldn't have these effects. But as I've already described, Pure didn't learn about this permit approval until the appeal had already been filed. So certainly they weren't consulted with, and they're right across the street. How it may affect them could not have been taken into account, which is what we're here to do today, is to provide you with that background as to why it would unduly or materially interfere with their use and enjoyment. Now, in pure submissions, written submissions at paragraphs 50 to 52, and in Ms. Leisure's witness statement at paragraphs 13 to 14 under tab 3, the reasons why the development would negatively affect the amenities and use and enjoyment of the neighboring lands is described. Now, some of these concerns include or surround the safety of the people attending, of course, pure site. People coming in and out of the casino at all times of the day. They park their vehicles in the parking lot. There's hundreds of them right next to where the shelter would be. Their goods are left there unattended, unprotected. And there's a concern, of course, to an increase of, as you've already heard from Mr. Robinson, an increase of risk of theft, damage to the property, and what impact an influx of 160 people would have on this. Now, these aren't baseless concerns. In support of those concerns, in Ms. Leisure's witness statement at Exhibit D are extracts from a Government of Canada document from their website titled Homelessness, Victimization, and Crime. And what it says is that the research alluded to in the report suggests that homeless individuals are more likely than the house population to engage in criminal activity. It also says a large number of homeless people are addicted to alcohol and illicit drugs. Now, an influx of people suffering from, not all of them, but certainly some who may suffer from these issues in this, I'll describe it as not a bare land, but there's nothing more there than industrial zoning, and then this shiny casino would negatively affect the amenities in the neighboring lands. This is a very real and warranted concern of how and reason why they would be affected. Now, in this regard, in Ms. Leisure's affidavit at Exhibit D is also an article from Global News from just this week, where it describes a man who was found shot and killed on, I believe, Monday outside Hope Mission's downtown location. One of the same locations where the development officers' written submissions describe people are going to be bussed in from to the proposed location. So it's a real concern. And it's certainly not a factor that can be ignored. I can't speak to what everyone else would think, but certainly in my case, if someone was shot and killed and there was an influx of homeless people around my home, my wife would be telling me, we need to consider moving. Now, what Ms. Leisure also goes on to describe are other concerns, including the effect on Pure's reputation and business. Their business is contingent on providing a positive and safe experience to its customers, and this raises a concern of that being impacted, which would impact their revenue and ultimately what they can do with their revenue for employees, for charities they donate to, because the revenue, one, it might be reduced, and certainly they will have to put that revenue elsewhere. As Mr. Robinson described, putting up security, additional fencing to address the influx of these individuals. Now, what also needs to be taken into account is not just the concerns for the neighboring properties, but what this would do for those homeless people. Now, of course, the goal of a shelter in the city is certainly a good cause. In this instance, it doesn't seem to be the right fit. It seems to be short-sighted. What would happen is that these individuals will be transported to a location they have no connection with. There's nothing around. They're a vulnerable segment of the population. They suffer from criminal activity, addiction issues, and they're going to be isolated in an industrial zone, smack dab in front of a casino. Logistically, it doesn't make sense. It could very much risk increasing the risk to those individuals rather than the ultimate goal of assisting them. And that's something that very much needs to be taken into account here. Now, for these reasons, we would submit the development would unduly or materially interfere with the amenities of the neighborhood or the use, enjoyment, or value of the neighboring lands. And for those reasons, it does not satisfy Section 640, sub 6 of the Municipal Government Act, Section 11.3 of the bylaws, and the permit ought to not have been approved. And similarly, we'd submit the board ought to not find in favor of the permit under 687, sub 3 of the Municipal Government Act in light of these concerns and how it would affect the casino and other neighboring lands. Now, subject to any questions you may have, or anything that may arise from the respondents, that completes my submissions.
Thank you, sir. I'll see if there's any questions arising from your presentation. Yep.
Mr. Snyder, one of the things the board has to grapple with is the definition of special event. And I'm just wondering if you could make some observations for us about not the naming of the provision in the bylaw, but the definition, and how, in your view, this doesn't fit within that definition.
Bear with me for one moment. So the definition is, yes, the definition is a temporary activity occurring for a limited duration. I believe under section 91.2, that's temporary for up to 45 days. This, of course, is 4.5 months approximately. So when it's outside of that parameter, which would take it outside of the special event designation for one. And temporary being 4.5 months, that's certainly, I'd suggest, a very broad interpretation of what temporary is. That's more, I could rent an apartment for 4.5 months and call it temporary, which really it's where I live. In this case, a temporary shelter for 4.5 months, it's where they're living. It would not be, in our submission, truly temporary or a special event as contemplated under the bylaws. Those temporary shelter services, that's residential use. That's why it's defined elsewhere specifically as a temporary shelter and supportive housing under residential uses, not a special event is in this case.
I think we need to take a step back and juxtapose the two definitions that are being referred to during these submissions. Sure, we've got the definition of special event, which means a temporary activity occurring for a limited duration. But embedded, and most importantly, embedded within the Edmonton zoning bylaw, we have a definition of temporary shelter services, which is defined as means development sponsored or supervised by a public authority or nonprofit agency for the purpose of providing temporary accommodation for persons requiring immediate shelter and assistance for a short period of time. Typical uses include hostels and overnight shelters. So let's just call it what it is. This is a temporary shelter service. Now, with all due respect, for a development officer to characterize this now as a special event is nothing more than not only a strained interpretation, but an artificial way to manufacture a use so that it can comply with the current zoning. And it goes without saying, if the legislature wanted to allow a temporary shelter to be operated in an IM, medium industrial zone, it would have included temporary shelter services as either a permitted use or a discretionary use. Even if the board is prepared to consider an argument that this ought to be characterized as a special event, well, sure, we've got this definition of special event, but we also practically and pragmatically have to rely on a degree of common sense. What is a special event? Well, an event that's something out of the ordinary to guide us in terms of the governing spirit and intent of the bylaw in this particular section. We look at section 91.3, which states under 91.3 or 91.2b, the siting of event, the location, size, and height of the associated temporary structures, including signs, the location and use of outdoor speakers and amplification systems sensitive to the adjacent residential uses, screening and buffering, hours of operation. This isn't a special event. This is a shelter. Let's just call it what it is.
Any questions? Mr. Jones?
I have a few just concerning the casino itself, and perhaps best directed at Ms. Leger. Hours of operation of the casino?
Our doors open at approximately 9:30 every morning, and closure is around 3. Although with some changes with the AGLC regulations, we're finding that we're able to be open 24 hours a day, and we're in the process of considering that for that property.
So 9:30 to 3 a.m.?
Yes.
And possibly going to 24 hours?
Our poker operation, which is a small section of the property on Argyle Road, is open 24 hours a day. So we do have a piece of the business that's open 24
Okay.
hours a day.
And what's your capacity for public to attend?
I don't know the exact number to
Ballpark?
that, probably 1,000.
And is there presently any screening when people come in? Is it just you walk in, or do you screen anybody entering?
We have security posted at the entrances, and they are on property during the hours of operation. And so they screen people as they come through the door.
Okay. And you serve food and alcohol?
Serve food and alcohol, yes.
Okay. And do you serve alcohol to people that are gambling free of charge, or do you?
Yes, we do. Oh, no, I'm sorry. 99% of the patrons that come to us pay for their beverages. The only time we do comp beverages is if they're like a high-value player, and that's part of the player development program.
Okay. So presently you have security. Do you have security in the parking lot as well?
The security officers patrol the parking lot from time to time, yes. The change here, if this is approved, would require us to have additional staff and additional lighting and, fencing around the perimeter, that type of thing. We're not currently equipped security-wise staffing for that type of patrol at the moment.
Okay, so you would anticipate some additional costs if
Definitely.
this was to go ahead?
Yes.
Okay. And then do you provide, like, let's say you have a big winter, do you provide escorts to vehicles, that
We
sort
do.
of thing?
Yeah, we do.
And are all the payouts in cash, or do you check?
Not
or-
necessarily. It depends on the amount of the payout. It
Okay.
can be by a check.
Okay. And I think that's all I had for now. Thanks very much for your
You're
answers.
welcome. Thank you.
Thank you, Mr. Jones. Mr. Snyder, I have one question in relation to this temporary shelter services argument. I don't believe that use is actually permitted or discretionary in any other zone. So I believe it's actually being phased out. So on that basis, would not looking at other potential ways of classifying this use be appropriate so that it could fit into conceivably some zone?
I think that's a great question. We're not aware of that. But I think that ultimately that's something that the governing body and the legislature has to resolve. And there is appropriate process under the Municipal Government Act to actually apply for a particular use. That was not done in this instance. And so in respect of the current state of the law and in respect of, borrowing from all of the principles that we're well aware of, procedural fairness, natural justice, interpretation of this legislative scheme, we have to rely on the law and the definitional aspects as they are now. Mr. Handa, I don't think either Mr. Snyder or myself can speak to whether or not this is being phased out. This is the first time I, for instance, have heard this, but that's ultimately something that the governing body will have to address and or could be addressed by way of an appropriate, fair application process as discerned and described under the Municipal Government Act. Mr. Snyder, do you have anything to add?
No.
Okay, my second question is from that definitional aspect, is it not possible for a development to fall under two uses and for the development authority to use their discretion to apply the use that they think is most appropriate? And what comes to mind are situations like home-based businesses. You could have a professional accountant, office support service use occurring in a house, but for zoning purposes, the development authority will consider that a major home-based business.
See, what we're looking at here, as I mentioned earlier, is the interpretation of a definition. And the argument is, look, if it's defined in the Edmonton zoning bylaw, and it's not a permitted or discretionary use under an IM medium industrial zone, we don't have to go any further than that. Sure, we could speculate and we could conject in terms of what the legislature meant in terms of, what you're describing as multiple potential uses. But we don't have to speculate because we've got a definition. That should be the end of the story. That definition, temporary shelter services, is specifically not referred to as a permitted use or a discretionary use and in an IM zone. So we don't have to get into a discussion about whether there could be one or more applicable definitions. The definition, temporary shelter services, applies squarely to this scenario, and it's not an allowed use.
Okay, and then just my last question would be then in response to the last SDAB decision on this point where the board did find a temporary shelter to be considered a special event in that situation. Did you want to address that decision in any way?
Sure, and we do address that in the written submissions, and what we'd submit is that's comparing apples to oranges. Apart from the fact that it was a temporary shelter, industrial zone, that's where the likeness ends. Now, in that case, the circumstances were very, very different, and just blindly looking at that and say, well, we did it here, we should do it here, there's a real risk to that. Every situation needs to be looked at on its own based on the own facts. So let's look at the facts of, I believe it was the Bocek case. That situation was in, I believe, the Ritchie Community League, an area that already had a number of shelters set up. It wasn't anything new, like in this instance, I believe there was 3 or 4 that were already there. It was immediately adjacent to a residential housing. The community league was open to it. They were committed to educating their residents and welcoming those homeless people. The homeless people there, they lived in that area already. They weren't being transported from elsewhere like would be done here. They were there. There was support. There was already a precedent in that area. And it was right on a location where there's transportation access. I looked at the Google map and I believe there's a school down the road. The Ritchie Community League was right there. Barb and Ernie's Country Inn was right down the street. It wasn't like this situation where there's very much just industrial businesses and then a casino. Here, the individuals don't have any connection. They're being shipped in. They're being left there in the middle of winter where there's nowhere to go, nothing else to do. There's not that support in the community and a precedent already.
And put some emphasis being put right in front of a casino for, a disenfranchised segment, vulnerable segment of the population who likely suffer from addiction issues or problems. And they're put right in front of a casino. Again, from a common sense perspective, you got 50, 100, 150 homeless residents in an IM zone with nothing else in the area, aside from, as Mr. Snyder described, a shiny casino. Where are they going to go? Where are these people, poor people, going to go? It's not fair to Pure, but it's also not fair to them. It's really seizing on their vulnerability. This was a short-sighted decision, not well thought out. The decision here on Bojack, right, and I'm referring to the decision I got right in front of me. There's a significant unhoused population in the rich community. This is not, and I'm quoting, this is not bare minimum shelter, but a supportive housing environment that helps individuals function within our society. The shelter provides shower and laundry facilities, meals, and staff assist with finding bridge housing and provide employment services to help residents find work. We're talking about something completely different. Goes on to say, we're talking about 2 different things.
And lastly, in addition to those points, the time was very different. In that decision, they talk about COVID, it being a concern. Sure, COVID still exists now, but 2 years ago, it was very different. The restrictions have been lifted. It's not the same as it was. And in that case, I looked at the Mustard Seeds website about this location. They don't describe it as a temporary winter shelter. In big bold letters, and this isn't the brief, but I have it on my phone here, they call it the Mustard Seed Temporary Pandemic Accommodation. It was for COVID. That's not the situation here, apples and oranges. So that case shouldn't be looked at and blindly applied here.
Okay, thank you, Mr. Snyder. Those are all my questions. At this time, we'll have you resume your seat back in the gallery there, and we'll invite forward Mr. Nickel.
Thank you.
All right, sir, the floor is yours.
Thank you, and I thank the group from Pure for the presentation they did and the homework technically to understand the permit and what was provided. I represent a group of 20 owners of a condominium complex for storage just south of where the property is being developed, and we're concerned about the traffic. The area is not set up for general population and to walk around. There are very few sidewalks for individuals to move around. Public transport is light in the area. There are very few street lights in the area. Just the community's developed to be an industrial business area. It's not developed to have hundreds of additional people moving around. So very concerned for the mischief that will be created as a result of the increased population and the needs of that population. So those are the concerns that we bring as owners. Thank you.
Thank you, sir. We'll see if there's any questions arising from your presentation. Seeing none, we thank you for your presentation. Next up, we will hear from Mr. Matharu. Sir, the floor is yours for your presentation.
Thank you. Morning all. Thank you for your time, Board. I'm speaking on behalf of Regency Innovations. Over the past 2.5 years, Regency has enjoyed the expansion of their business at 7021 Gerard Road, which is literally right next to the proposed property. And they have grown practice and clientele in a new facility, and they're a small, proud business owner in the Davies industrial commercial community. And also will be there for many more, hopefully many more years to come. Ultimately, we are strongly oppose the development of a Hope Mission supportive housing. Criminology studies provide clear support that the presence of homeless shelters increase property crime rates. For instance, in Vancouver, property crime rates increase by 56% within the 100-meter radius of surrounding a homeless shelter. Furthermore, the Edmonton Police Service has released data showing that crime severity is 2 times higher in the area surrounding emergency shelters. Even this week on January 2nd, 2023, a suspected homicide occurred outside the Herb Jameson Center. You know, with millions of dollars in property and machinery in the surrounding area of a facility that will bring crime, it is clear to see our unease in the approval of this permit. As a consequence of the increased crime anticipated with the introduction of this Hope Mission facility, the property value will also face an unprecedented decline. The Boyle Street community in the central Edmonton and neighboring in the vicinity of a homeless shelter saw such declines in property values. With the adjustments our businesses had to make throughout the pandemic just to stay in operation, we are incredibly dissatisfied with the decision of the board. Still, we cannot ignore the fact that homelessness is a primary concern in Edmonton, and it is a social issue that needs immediate resolution. Ultimately, homeless shelters do need to be developed, but there are several more appropriate locations for such facilities. We have also submitted the documentation online. First of all, you must be aware that the Pure Casino is located on the property directly across from the proposed development. Argyle Liquor Link and Cannabis House Argyle, a liquor store and cannabis dispensary respectively, are also both on the same street as proposed Home Mission development. Both of these businesses, like the Pure Casino, provide further risk factors for Edmonton's most vulnerable population. You know, successful homeless shelters should be based on prevention-oriented solution. A shelter beside a casino, liquor store, and cannabis dispensary does not in any way prioritize prevention of the vulnerabilities that homeless individuals face. You know, the city of Edmonton currently operates Victoria, Rundle Park, and Riverside golf courses, as well as Northland Coliseum. All of these facilities are non-operational during the winters, and, you know, seem much more reasonable for Edmonton's homeless population. Then upon reviewing the site ranks, it is clear that temporary shelter makes only a small fraction of the proposed facility. As it appears, Hope Mission is leveraging the promise of a temporary shelter using government-funded money to build new administrative spaces, leaving the social significance and objective of shelter in the backseat. I would like more transparency from them on this topic at least. Over the course of this letter, I have outlined several undeniable pieces of evidence supporting that the development of a Hope Mission shelter in the neighboring property will bring a lot of crime and negatively affect a lot of other businesses and our businesses in several ways. All the evidence is provided for reference by the end of this document. To close, I ask, staff to consider one question. Can you refute all the evidence I have included in this letter if and when you realize that this evidence is irrefutable? You should also realize that the Hope Mission property should not be developed. Thank you.
Thank you, sir. I'll see if there's any questions arising from your presentation. Seeing none, we thank you for your presentation
Thank you
today
all.
and for appearing before us. All right. Next, we will hear from the city. So, Mr. Gunther, I'll invite you and Ms. Louie and Mr. Luke up, and you're free to present in whichever order you deem fit. But you know the drill, so I'll stop there.
Well, good morning, Mr. Handa, members of the panel. My name is Michael Gunther. I'm legal counsel with the City of Edmonton. I believe I've appeared in front of most, if not all of you before. To my left is Cindy Louie. Cindy is a development officer at the City of Edmonton. To my right is Harry Luke. Harry Luke is the development supervisor at the City of Edmonton. Both Cindy and Harry have been involved in this file essentially since the outset. I've been brought in more at the back end as things have progressed, and it's appeared that we would be heading to the Subdivision and Development Appeal Board. Today, our role here as the development officer is to do two things, and that is to explain the rationale for why the development officer made her decision as she did, but it's also to justify that in the context of the legislative scheme, the zoning bylaw, the various considerations, discretion that play into this decision. It's not to ultimately say that this project, as proposed and has been proposed by the Hope Mission, is a good idea or a bad idea, or that the development in its specific specifications will work or will not work, but rather to explain a little bit of the legal context that went into the decision making and ultimately do our best to justify why we feel that what occurred here was the right decision from a legal and a factual perspective. What I'm going to do in a minute is I'm going to turn it over to Cindy to explain why she made the decision she did, ultimately go through the development approval. But before we do that, I think there's 2 points that I want the board to look at almost as a lens through which Ms. Louie will explain her decision. And the first of these 2 points I think is really important, and that is we're not talking about a development approval that is going to last for a year, or even like the Boyle Street matter that some of us were involved with a few months ago, for generations to come. By the time the board has rendered its decision and that the proposed development is operational, we're talking about a 3-month, slightly over 3-month window that is proposed to be operated here. So we're not talking about something that is of a permanent or even a long-term temporary duration. So I think that's the first point. That is part of the lens that I think that we need to listen to Ms. Louie's comments through. The second point is a little bit more sensitive, but I think it needs to be said, and that is that every single shelter approval, whether it's approved as a permitted use or a Class A permit, a Class B permit, as a special event, as has been done before, or supportive housing, or back when temporary shelter services was a use that was actually listed in the bylaw. I've been at the city for almost 12 years now. Every single approval of this nature is appealed to the Subdivision and Development Appeal Board, and ultimately, each time that we appear before the board, The comment is that there are, quote, more appropriate locations for a shelter of this nature. And so ultimately, as the board listens to Ms. Louie and ultimately Mr. Luke as well, if he has additional comments, I think it's a very important lens to consider, well, if not here, then where? Because I think we all acknowledge that there is a homeless population in Edmonton that needs support, and that ultimately it is incumbent upon service agencies and the City of Edmonton to ensure that these supports are in place somewhere. And ultimately, whenever we find ourselves at the board, the suggestion is that there is some other hypothetical place out there where a shelter service, whether it be a short-term special event shelter or a longer-term use, ought to exist. And so I think that's an important question that the board needs to consider today in the back of your minds. If not here, in this industrial, commercial location, then where? So with that, I'm going to turn it over to Cindy Louie. She's going to take the board through her approval. If you have questions of Ms. Louie, feel free to ask those questions at the conclusion of her presentation. And then I'm going to take the board through some of the legal framework that is germane to the issues of this case.
Great. Thank you, Michael. Good morning, Mr. Chairman and members of the board. Before I go through my decision and thought process behind that, I just want to share some relevant background. And the existing building was approved on September 7, 2022. It was an existing building, but changed the use to maintain the general industrial use building. And there are accessory commercial uses that include office and a secondhand store that the Hope Mission warehouse and thrift store was operating. At the time, there was no appeals. So the applicant is ARC Studio, and they submitted a development permit representing the Hope Mission and described the proposed activity as a temporary shelter to provide access to safe shelter and basic needs that include overnight and day sleeping beds, meal services, breakfast, washrooms, and water closets for an emergency and support service for people experiencing homelessness in Edmonton. Transportation is going to be provided to the temporary shelter location from downtown sites at the Hope Mission main building and the Herb Jameson Center. The location of the subject site is in the industrial area of the Gerrard Industrial Neighborhood, and the surrounding area is primarily industrial-based zoning. The proposed development has been approved as a special event, or a temporary shelter in this case, within a general industrial use building with, again, maintaining the existing accessory office uses, and they're doing some interior alterations. And the limited time duration to operate this shelter will be from December 15th, 2022 until April 30th of 2023. And there will be a maximum of 160 people. So in reference to section 7.815 of the zoning bylaw, a special event is a community educational and recreational cultural service use class, and it's defined as a temporary activity occurring for a limited duration. So this use clearly describes that it doesn't include cannabis lounges, cannabis retail sales, cannabis production and distribution, body rub centers, or adult mini theaters. The Development Authority's opinion is that the nature of this temporary activity is a supportive housing use. However, when taking direction from previous decisions of the Subdivision and Appeal Board, in 2020, I'm going to reference this case law as ABE SDAB 10164. This use will also conform to being deemed as a special event use. So the following variances were granted. The use is discretionary because of supportive housing was deemed as a special event use in reference to 7.13b. Secondly, in reference to section 91.3, the Development Authority approved the special event for a duration of longer than 45 consecutive days. So in reference to section 3.2.1s, temporary shelter services is deemed to be a supportive housing use. However, supportive housing is not listed in the IM zone or medium industrial zone. So when referencing section 7.13b in the zoning bylaw, when there are specific purposes or activities that do not conform to any use definition or generally conform to the wording of two or more use definitions, The development officer may, at their discretion, deem the purposes or activities to conform and are included in that use which may consider to be the most appropriate. In such case, the use shall be considered discretionary use, whether or not the use is permitted use or discretionary use within that applicable zone. The Development Authority considered the special events use in this case to be the most appropriate, given that the non-permanent scope of this proposal and the Subdivision and Appeal Board's confirmation of a similar approach to the issue in December 2020. The Development Authority notes that any land use impacts to this decision are limited for a short defined period and will cease at the time of the permit expiry. So as a development authority, I did weigh the emergent need to accommodate the situation to house displaced citizens within temporary locations for emergency winter shelters, and I did exercise discretionary powers to render this DP development permit decision and deem the proposed temporary development as a special event. The temporary location proposes to operate for several months during the winter of 2022, which has now ended, into 2023 of April. The Hope Mission seeks to open this location December 15, 2022, close on April 30th of 2023. There are going to be 160 sleeping mats on the site. However, the current floor plan is showing 120 sleeping mats. The approach is to align with the city's plan to end homelessness and provide temporary housing and urgent needs for the vulnerable individuals, especially during winter months. And also this decision is also consistent with section 1.1.1.1 of the city plan, which notes that as long as homelessness persists, the city will establish basic amenities throughout the city for people experiencing homelessness. The Development Authority also notes that this proposal helps to diversify social service agencies outside of the downtown core and will serve an area of the city with limited other supports to persons relying on social agencies to meet their basic needs. Given these above observations I've shared today, including the time-limited duration of the proposal being very temporary, the proposed development would not unduly interfere with the amenities of the neighborhood or materially interfere or affect the use, enjoyment, or value of the neighboring properties in the opinion of the Development Authority. So as a development that is a discretionary use, notices were sent to the neighborhood, to the affected parties within 60 meters, and as a result, there has been several appeals filed. Thank you.
Thank you, Ms. Louie. I'll just see if there's any questions first from Ms. Louie. Ms. Monroe?
Ms. Louie, I'm not actually sure if this question is for you or Mr. Gunther, but I'll let you decide. I think I heard you say that in the previous board decision in 2020, the board deemed the use to be a special event use. And when I look at paragraph 62 of that decision, I don't see where the board used the deeming provision. My reading of that is that the board just found, as a matter of interpretation, that the use fits within the definition in the zoning bylaw. Could you comment on that, please?
Okay.
Yes, I can take that one, Ms. Monroe. That's an interesting question, I guess, kind of academically, but I think what happened in the Bocek decision was that the development officer used the deeming provision, and then when it went to the board just simply found that it was a special event and didn't actually rely on the authority under section 7.1 of the zoning bylaw that actually allows the deeming to occur. The board just simply found that it was a special event. So I think that you make a valid point there, that the board didn't necessarily need to invoke that power and just ultimately found that it was a special event.
Okay, thank you.
Mr. Jones?
Thank you for your presentation. I just have a couple questions considering this previous permit that we had been discussing. Does the city do any follow-up with respect to how successful that operation was or what happened during that time frame?
The previous permit on the existing site, the city does go, like, after the development permit's issued, we have safety codes officers that do check the inspections of the building permit to ensure that it meets life and safety code requirements. And then afterwards, there is business licensing that needs to be applied for, and follow-up inspections could occur if there's any concerns.
Okay, but any feedback from the community as to how it went?
Just to be clear, correct me if I'm wrong, Ms. Louie, but I don't believe the previous permit was for the same use. It was for as a thrift store?
Correct. I just wanted to reference that as relevant historical permitting, just because there is an existing permit that is a thrift store, but it was for the home mission, and there was no concerns or appeals at the time.
No, I'm not talking about this site. I'm talking about the permit that we talked about that had been granted by the SDAB.
Oh, it's
Yeah.
the Susco site.
Because it was a similar situation, industrial site, temporary shelter. So any feedback that you received about that?
Yes, and I can't speak to specific feedback and don't have any documentation on that. I don't know if Ms. Louie has more about that, but it did run its course, and ultimately it's no longer there because it was a temporary special event. So whatever did occur was for a short duration in time.
Okay. And the date of the permit lists from December 5th to April 30th, and of course we're into January, so the April 30th would still be the end date regardless?
Yes, correct.
Okay. And is there somebody here from the Hope Mission that will be speaking? Okay, well, I'll leave that question there, because I had some questions about the day-to-day operation of this facility, but I'll leave it for that. So thank you very much.
As part of their submission, there was an operations plan as well.
Thank you.
Thank you, Mr. Jones. Mr. Peterson, any questions? Ms. Louie, my question's in relation to what Ms. Monroe was asking. Why did you feel you needed to use the deeming provision, given that in the last SDAB decision, the board just found it to be a special event? Again, I kind of look at when we're doing home-based businesses, it's not like we don't usually see a deeming provision used there, even though we've got a use that fits into two categories most of the time. So on this occasion, why did you feel like you needed to use the deeming provision?
Yes, so in section 7.3, as I mentioned, there is that ability to do deeming authority for the developmental officer. And in the IM zone, there is a special event use that's permitted. How it's defined is it's a temporary activity occurring for a limited duration. So the activity it could be defined, I guess, through my interpretation, being a special, a shelter use. In my opinion, it does fit as a temporary activity. It is going to end in April 30th. Activity is not being restricted to a shelter. It does have provisions here saying that it can't be cannabis lounge, cannabis retail, or cannabis distribution and production and body rub in adult theaters. So it's very clear that those uses are excluded. And I just, in my interpretation, I did feel that deeming it was appropriate.
And then in terms of the variance, is that actually a variance that needed to be granted, or are you just applying an exception in the bylaw that doesn't require you to then grant a variance? I guess my questions are leading to a possible conclusion that this might be a permitted use and no variance was actually required. And in that event, it's a Class A, and we know how Class A's are treated. So maybe a question for Mr. Gunther or both of you, but is that not a possible outcome in this scenario?
It's an interesting observation, and it's one that came to me at about probably 10 o'clock last night as I was kind of going through some of the materials that have been submitted in this matter. Given that there is this provision in the bylaw that allows for the development officer to exercise discretion to allow specifically for a longer special event, I think there's a pretty compelling argument to be raised that it is not a true variance in the sense of the word, but rather just an operation of discretion that can be found within the zoning bylaw. And if that is the case, and ultimately if the board turns its mind to it and finds that that is the case, then I think it would be a permitted use, no variances.
Okay. Thank you. Those are my questions. Anything further? Seeing nothing. Okay, please proceed with whoever wants to speak next. Mr. Gunther.
Before we do so, is there anything further Mr. Luke wanted to add?
I just want to add that, again, we went through the process, not unlike all other applications with respect to these types of temporary developments. Again, it's already been explained of how Ms. Louis came to the conclusion based on her detailed review. You know, again, it's interesting, section, I'll respond to one issue that one of the appellants brought up, I think on behalf of the casino, and that was the actual regulations of a special event. And again, there is no reference to any type of special event, whether you put up a temporary structure or not, related to the special event. In this case, the building was already facilitating the special event, so there was no need for any ancillary buildings for any temporary purpose. So again, as a point of fact, Section 91 does not specify any type of special event, whether it be for a live performance, or whether it be for a casino extension, or whether it be for a temporary shelter, for that matter. And again, this is strictly matter of fact, and I think we took that into consideration. That's it. Thank you.
Thank you, Mr. Luke. I'll just see if there's any questions for Mr. Luke. Seeing none, Mr. Gunther, please proceed.
Perfect, thank you. What I'd like to address is sort of, I would say, falls into three different buckets. And the first is just wanting to speak to the approach generally that the development officer has used, and that is the classification of this proposed use into the special event use class. The second issue that I'd like to talk about is exercising discretion, and ultimately the discretionary element that the development officer has applied in this case, both in the context of relying on the deeming provision, but also in the context of extending the use or the special event use to beyond the 45 days that's set out in the bylaw. And then finally, I just want to talk a little bit about the variance test in the event that the board relies on the variance test, and just speak to some of the comments about how the variance test is applied and how the courts have applied that. I will start by saying that when it comes to the first bucket, so the approach generally that the development officer has used, I'm not sure the comments of my friends Mr. Snyder and Mr. Moodley accurately reflect the operation of how the City of Edmonton zoning bylaw works and how 2022-23 planning law would apply to the context that we're dealing with here. I will first start by saying that as this board is aware, we receive feedback, Ms. Louie, Mr. Luke, the Development Authority generally, from the decisions that are made. And if the board disagrees with the decisions that are made by the Development Authority, your decisions are the way that you tell us that. And ultimately, in 2020, a very contentious approval went before the Subdivision and Development Appeal Board, where the same approach was taken by the Development Authority to allow a special event to be used for approval for a temporary shelter. Now, in this particular case, like today, it was quite contentious. Unlike today's case, directly across 99th Street from where that particular shelter was, there was the Ritchie neighborhood, a community league that was involved, and ultimately a whole residential neighborhood, a matter of meters away, feet away from where this proposal was to occur. And ultimately, what the board did find was that, notwithstanding some of the concerns that were raised by the community, that firstly, the special event use that is found in the zoning bylaw is an appropriate method and mechanism where there is a use that is of a limited duration. That's fundamentally what this use class is any development of a limited duration, except for the ones that are specifically listed. So the cannabis lounge, the adult mini theater, the uses that are perhaps more of an adult nature. Anything else in the zoning bylaw, as long as it's of a specific time limited duration, can fall into this classification as a special event. And in the case of the Cesco site, I think it's the Bocek decision, that's exactly what was applied, noting, of course, that this is a community services use. So fundamentally, a special event refers to a community service use, which serving the vulnerable and homeless community ultimately is, at its core, is a community service use. That's not to say that there could be other uses. I think in the bylaw there's a reference to seasonal plant sales, which is one type of special event. But there's certainly nothing in the bylaw that would constrain the special event use so narrowly as to say that it is limited to festivals or public events of the nature that is perhaps otherwise suggested. This is also not a case, having looked at the submissions last night that were prepared and filed yesterday by the appellant, where the use definition actually constrains the hands of the board. The use definition for special events is incredibly broad. It's not as though it's a situation like in the Edmonton versus Edmonton case, which is commonly known as the Greywall case, where the use definition itself prohibited the board from actually exercising discretion and allowing the use. So that case is not one that really would bear on the facts of this particular matter. Ultimately, what the zoning bylaw is about and why we even have a zoning regime is because of land use impacts. And fundamentally, the land use impact of any use for a 3-month or 4-month period, it's going to have a discernible and identifiable end. It's an opportunity to determine perhaps what the bigger picture land use impacts might be. For example, if down the road in another location or the same location, we were to have a proposal for a shelter type use in an industrial neighborhood. This is a particular case where the proposal is only for 3 or 4 months, and ultimately any land use impacts that would occur are coming to an abrupt end as of April the 30th because they're not permitted to operate beyond that. That is why I think from almost an academic perspective, there is this separate use class of a special event in the zoning bylaw, is because we know council in their drafting of the bylaw has recognized that these uses that only last for a limited duration are not going to have the land use impacts that things that could last for years or generations might ultimately have. Moving on to, I guess, the second topic or the second bucket for discussion, and that is the exercise of discretion. And in terms of the development officer exercising her discretion, both in the context of deeming this to be a special event as she did. Now, that's not saying that the board needs to use the deeming provision. That's simply just what Ms. Louie did when she was assessing the permit. But also this discretion to extend the use beyond the regulation that says that 45 days would generally be the limit for any sort of special event use. Discretion has to be exercised judicially as a public body making a decision. We can't arbitrarily say, well, no or yes, but not necessarily turn our mind to why we would exercise our discretion in a certain way. A case that I was looking for, because it speaks to discretion and the exercise of discretion judicially, Miller and Joint, 2007, Alberta Court of Appeal 214, notes that discretion must be in a quasi-judicial context. So in your role, but also Ms. Louie's role, must be exercised judicially. In particular, it must be based on evidence and not speculation. And I think that's an important point for not only what Ms. Louie was undertaking in her exercise, but also your task today, because what I think we have and what has been put forward are concerns, and they're concerns that can certainly be taken into account in the big picture by the board. But I think we need to be very cautious not to rely on speculation or potential hypothetical scenarios, but rather what evidence is truly before the board. And having looked through the materials that were filed last night with respect to the affidavit of the representative of the appellants, there are several pages taken from a document, which I was able to find the entirety of the document. It's available online for download, which are taken as a snippet or a snapshot of certain comments regarding the prevalence of crime amongst the homeless population. Now, if we look to the entirety of that document, which is available online, we see it also includes recommendations as to things that can be done, including providing supports for homeless people to ensure that those issues which have been identified are not of concern to the effect that they will impact the community. In terms of what sort of impacts a homeless shelter might have on whether it's an industrial community, a residential community, a downtown community, it raises some uncomfortable questions. And I think one of those questions is it the fact that there are homeless people in our community that perhaps lead to some of these concerns, or is it the use itself, the homeless shelter itself? Is it the use, or is it the user that is ultimately the consideration that is of concern to individuals who are raising these issues? I also thought, as I was working through these materials, the case of the Supreme Court from a number of years ago dealing with safe injection sites, the PHS Community Services case. The citation, if the board wants to go into it, it's 2011 SCC 44. And at first blush, this is a case that may not be, appear to be on all fours with what we're dealing with here, because it dealt with a constitutional division of powers issue and Section 7 charter rights of people who are drug users. But there is a really interesting analysis and commentary in that case, because what it talks about is that all the opposition to the existence of a safe injection site, at least on that record, was due to community harm or the fact that drug users were tied to crime. But in reality, there was no evidence that was put forward on that record as to whether or not safe injection sites actually created any sort of criminal issues, or if there was perhaps a crime issue that already existed, and perhaps this was something that was treating those issues and maybe ultimately would lead to a decrease in these concerns. And so what the Supreme Court in that case talks about is, and it's towards the end of the case, there's a bit of an analysis and discussion saying we can't just simply presume that the existence of a safe injection site, or in this case today, a service that provides support for homeless folks, is going to lead to these land use impacts, or in the case of a safe injection site, criminal activity in the community. There's no evidence to that effect. We can ultimately look at the big picture, but at the same time, we need to be cautious that we're not relying on prejudices, but rather what is on the record in terms of evidence that could impact or could sway the decision of the development officer or the board today. In terms of exercising her discretion, Ms. Louie has ultimately applied the deeming provision. I am not certain that the board needs to do that in reaching a decision today, but in the event that it does, in the event that you as a board feel that that provision needs to be relied upon, I would reference the fact that there are various reasons why this makes sense contextually. It is a limited duration proposal compared to the circumstances in the Sesco site case from 2020. We're dealing with an area that is even less residential in nature. We're dealing with institutional organizations like a casino that already have security on site and have, quite frankly, the resources, as opposed to an individual homeowner who can't necessarily, if they're concerned with crime, hire a security guard to sit out front. This organization already has that as part of their operation. In terms of whether or not this is a so-called industrial zone, I had regard to the zoning bylaw. Actually, it's the provision right after the deeming provision in the zoning bylaw. And I will just pull that up for you. It's 713C. And it says the headings such as residential uses or commercial uses do not mean that the uses listed under these headings are permitted only in residential or commercial zones of the bylaw. Reference must be made to the lists of permitted uses and discretionary uses within each zone. And the significance of this provision is simply because we call something an industrial zone, or in this case, IM, medium industrial, that doesn't mean the four corners of that zone are limited to uses that are of an industrial scope. It's more, we have to look to what the listed uses are, because it may be that certain uses are allowed in that so-called industrial zone that maybe one wouldn't necessarily think are truly industrial, like there are listed uses in the industrial zone. I believe even urban indoor farms is something that might be found in an industrial zone. A casino, for that matter, is something that ultimately might not be considered industrial, yet is still found in this industrial zoning. My final comments go to the variance test, and I think the board is very well familiar with the variance test. I need not go too far into section 687, sub 3, sub D, but I did want to draw the attention of the board to paragraph 49 of the library cases, but obviously the seminal cases on the variance power, because there's a discussion in that paragraph, in paragraph 49, that recognizes that all land uses have impacts. Anytime your neighbor builds something or starts a new development or use on their property, it's going to impact a neighbor. But the Municipal Government Act and the variance test uses the term undue impact, or would not unduly impact, or in terms of value, would not materially affect the value. And this discussion at paragraph 49 of the library cases talks about how some impact is acceptable, some impact is inevitable, and it's only where the impact is unduly harsh or materially impacts the value that we are talking about a problem from the variance perspective. Now, in this particular case, given the time-limited impact of this particular proposal, it is something that there inevitably, like with any development, will be land use impacts for a period of time for the short duration that we're proceeding into if the development is approved. But at the end of the day, those land use impacts will come to an end. To the extent that the development officer relied on this section to inform her decision, it's ultimately not something, in our view, that would be undue. It's not something that would be a material impact to value, notwithstanding the fact that there is no meaningful evidence on valuation impact in any event. In terms of the impact on the neighborhood, it wouldn't be something, to the extent it exists, that we, in assessing the file, would believe to be material or undue, having regard to the fact we are an urban municipality. We do have homelessness issues throughout the community. The city plan recognizes that supports for homeless individuals are to be provided not just in the downtown core, not just in Old Strathcona, but throughout the city, and that after the pandemic and in the world we live in now, we do have this issue in our community, and that ultimately someone has to deal with it. So that's where we are today. Ms. Louis' decision, I believe, from a legal perspective and from a factual perspective, is sound. We'll hear some more from the applicant regarding the specific parameters and proposal that is being advanced here. We can't speak to that, but subject, Mr. Handa, members of the panel, to any questions that you might have, those are my legal submissions for you.
Thank you, Mr. Gunther. I'll see if there's any questions arising from your presentation. Seeing none, I thank you for your presentation today, Mr. Gunther, Mr. Luke, and Ms. Louie. Thank you all for appearing before us today. We will now hear from the Hope Mission, and then we'll have a brief recess before we do our rebuttal. So Mr. Reith and Mr. Corzan, you may join us here at the front, and the floor is yours.
Good morning. So I'm Bruce Reith. I'm the director of Hope Mission. Gary Corzan, also from Hope Mission. So Hope Mission is a Christian mission that's been in Edmonton for 94 years. going back to 1929. I have personally run emergency shelters in Edmonton for 30 years, going back to 1992. And usually in past years, summertime, we would have 300 to 400 homeless people staying with us. Wintertime, 500 to 600. But this past year is just, I've never seen anything like it. And at Christmas time, you know, when we had the cold spell, we had 854. Last night we had 801, the night before 817. Puts a tremendous pressure on the staff in regards to those numbers. In 2021, we opened up the new Herb Jameson Center for men, and we have the Hope Mission building, which is about a block away for women, and then overflow. But we're right, we can't handle anything more than what we have right now. And so the concern is it's a winter city. We can get up to the 30 below. So last year, I was sharing a warehouse in the Argyle area. There was a fire. We were wiped out. We lost our food truck and all our donations, the sorting area that we had. And so in May of last year, we bought this warehouse on Gerard Road to be our distribution center. But we were surprised that since then we've been broken into 4 times. A couple of white brand new vans that smashed through the gates before we get our security up. They took all our tools, they took our donation, a lot of the best. And then behind the building is a rail line. I call that Hobo Trail. A lot of them run past there. There's existing homeless people already there before we got there. And they've broken in and stolen stuff or slept in the Quonset hut. So there is existing people that don't go downtown that are in that area. One of the owners who bought a warehouse on that Gerard Street said when he bought his building, there was a homeless person living in the building that he had bought. So it's not like we're bringing homeless in, they're already there. I guess for us, we're looking at this as temporary till April. It's a winter city, and then it's done. And then we can continue on with the thrift store, and I guess it's going to be a distribution center. We have our laundry there. We have to clean our blankets after one use because of lice and bed bugs. We're going to get freezers, donations from Costco for meat, that sort of thing. We send old equipment from Alberta Health Services to hospitals in Cameroon and all over the world, and that's kind of our distribution center. The thing is, there is no other place. I know that the Mustard Seed is trying to open up at Coliseum Inn, and so if they opened up, then that would relieve pressure. Jasper Place Health and Wellness is in the West End, and they are trying to open up a hotel. Homeward Trust has got 4 buildings that they've just opened up, and it's focusing on the chronically homeless. And so I see relief, but they're all going through renovations and struggles to get permitting and whatever. We're talking right now as a temporary situation. I just want to get to April. And like I said, we're right there with, like I say, I've never seen numbers like that. And so that's just where we're at, and that's what we're trying to do. And there was a question about us getting government money. I get audited every government contract, so I have nothing to be ashamed of or whatever. We're transparent in regards to that. MNP, a national firm, looks at everything that we do. So anyways, that's all I had to say, unless you have some questions. I guess in regard to, I think you wanted to know about the operation of it. What we'd like to do is, it's not a 24/7. We have 24-seat vans, and so the logistics of after 8 o'clock, probably get them there at 9 o'clock, and then there'd be cots, and there's washrooms and an area for as part of this warehouse. We're not going to feed them. It's just to take off the pressure from downtown. They're going to be there first thing in the morning, then we take them back for a hot breakfast. And so there's not showers or laundry. It's just basic washrooms that we've set up with the cot just to relieve pressure from downtown. And so let's say in the night there's a problem with somebody. We have 24/7 ambulances going around the city all the time, which we can call in to take a particular person who was a problem back to the shelter, if that, and that's happened. We've done it at Central Baptist, where it's overflow. We had 60 people over there. I've gone to the Commonwealth Stadium. We've gone to the old racetrack to run shelters. This is nothing new for us, so anyways.
Thank you, sir. I'll see if there's any questions arising from your presentation. Mr. Jones?
Yeah, just to follow up on the operation aspect. So you would pick up people from various parts of the city, you'd bring them there, they spend the night?
No, I'm just talking about people that come to Hope Mission.
Okay.
And so I'm not looking for more. I'm just the ones that come to me. And once it hits over 800, it's really, really stressful. And so I would try to relieve some of that pressure. I guess my plan was, you know, if you had the 24-seaters and you took maybe 30, 40, 50 just to take the pressure off from downtown. But if it starts going over 900, 1,000, and we can't seem to get Mustard Seed or Jasper Place Health or all these other places open, that's the situation. For a cold city, April comes, we made it.
Okay, so this is kind of an overflow situation
Yes,
for you then?
that's right.
Okay.
And you know what? Maybe the numbers, if they go down, great. It's not like the logistics of going to this is going to be fun. Like it's, if I can keep everything downtown, because I have my 2 buildings and my staff and everything is there, all the meals, laundry, everything is there. That would be the best. But what happens if my building is 42 years old, the Hope Mission building, pipes break, you know, it's 40 below, floods, I have to do something. It's sort of like a backup. I would try to get 160 people over there in an emergency.
Okay.
So,
Well, first of all, I congratulate you on the work you do, because I'm sure it's very difficult work. But I guess just getting back to the specific site. So from what you've explained, it's an overflow situation. You've got surplus wherever you have them. You bring them there, they spend the night. What happens from that? They spend the night there, they get up in the morning. Do you take them somewhere after?
Yeah.
Are they on their own? What
no,
happens?
so they would be picked up at Hope Mission downtown, and you try to keep the troublemakers downtown. You try the ones that just, they're tired, they're weird, they just want to sleep. And so we put them in, we drive them directly to the warehouse about 9 o'clock, and then get them settled in on their cots. There's washrooms there. Then first thing in the morning, before 8 in the morning, we're loading them up and taking them right back to where we had them, picked them up at Hope Mission, and breakfast is on. They can have a hot breakfast.
Okay. And if they choose not to, they can just go, or?
Well, and that's the thing, because it's Hope Mission Shelter is not a prison,
Right.
you know.
Okay.
But if they're going to be taking off, then we can't control that. But I'm trying to find ones that I can just take the pressure off that aren't my troublemakers. 90% of the homeless are not a problem. It's that 10% that would be the troublemakers, and we try to keep them downtown.
It's kind of 10% of everything, isn't it?
I guess.
Okay, thank you, sir.
Thank you.
Thank you, Mr. Jones. Any further questions? Mr. Bedinsky?
Thank you. I was just wondering, do you have any security staff that will be located at that warehouse?
Yeah, we'll have 4 staff. So it's, what I like is it's one open warehouse area and with washrooms. And so the staff are there, they're with them all night, the whole time. So it's not like we just put them in there and everybody goes home. We're there, and if there's trouble, they can call in the ambulance, like our ministry van, pick them up and get them out and get them back to Hope Mission, is the plan.
Is there like a check-in procedure, like if someone decides they want to leave, do they just walk out, or they've informed you that they're leaving and you check them out, or?
Well, these are very colorful people, and you never know.
Yeah.
Yeah.
So there's 4 staff total?
Yes,
Okay.
at the warehouse.
Okay. Perfect. Thank you.
Okay.
All right. I have no questions for you, so we thank you for your presentation today. At this time, we'll take a short recess. Let's take a 10-minute recess, and we'll resume the hearing at 11 o'clock. Thank you. All right, are we good to go? All right, Mr. Snyder, we'll invite you back up for rebuttal. I believe Mr. Robinson, is it? Yeah, I believe he's left, so you're the only appellant left here for rebuttal. So the floor is yours.
Thank you, everyone. Just a few points arising from the submissions of the respondent. Now, while my friend Mr. Gunther's submissions were creative, one aspect that was very much steered clear of was the definition of the temporary shelter services. And we'd submit that was for good reason, because you can't get away from it. It's there, it's in the bylaws. It's something that you, as a board, need to look at and consider. It's a planning decision that has to be made. This is an industrial zone, temporary services, temporary shelter services, it's defined elsewhere, not as permitted use for an industrial zone. Now, heavy reliance has been put on the Bocek case by the development officer and my friend. And we already spoke to that, but there are some points arising from the submissions that need to be addressed. One, this board's not bound by stare decisis. Sure, a decision was made, but you are an independent board, right, wrong, or otherwise. You aren't bound by that decision. What needs to be looked at is this case and the specific facts. We've already gone over and distinguished how that case is entirely different. I believe in that case there was reference to no evidence of increases in crime with homeless. That's not the case today. I don't believe anyone even appeared at that hearing in person in opposition. I might be mistaken, but from my recollection, that's the case. That's not the case here. There have been numerous people in opposition providing reasons as to why this permit should not be granted.
And the two key distinguishing factors, just maybe a tad repetitive, but it borrows from what our friends at the Home Mission said. And to our friends at the Home Mission, gentlemen, thank you for the work you do. It's admirable. We're here today, of course, arguing over what we think was a poor planning decision. And nothing should be taken from this as, offensive to you and the good work you do. But my friends from the Hope Mission characterized the operation of the facility out of the warehouse. But that's another distinguishing factor, because in the Bocek decision, that was in a neighborhood where there was a housing need for marginalized people, homeless people. And the SDAB in that decision went on to say that paragraph 37, this is not a bare minimum shelter, but a supportive housing environment that helps individuals function within our society. The shelter provides shower and laundry services, meals and staff, and assistance with finding bridge housing. That's not what we're talking about here.
And on that point, it's relevant to the development officer's decision. In the development officer's submissions, it seems to almost pull verbatim from that case and plug in stating, the applicant Arc Studio submitted a development permit application representing the Hope Mission and described the proposed activity as a temporary shelter to provide access to safe shelter and basic needs that include overnight and day sleeping beds, meal service for breakfast, washroom and water closets, and as an emergency shelter. that sounds like Bocheck, but hearing today from Hope Mission, that's not the case here. And that's what the permit was approved based on, at least in part. So that's another difference that needs to be taken into consideration. Now, there's been a lot of discussion about the discretion of development officers, but that's important in this. It can't be an unbound discretion to do whatever they want. It has to be curbed and constrained by the bylaws. It's not an endless essential power to find anything to be a special event, and anything can be approved for any zone. The definitions of the bylaws lose all meaning, which is something I described previously, but is worth reiterating based on the submissions of my friend. Now, finally, in turning to the variance test, my friend Mr. Gunther had referred to a library board decision, and I believe he referred to paragraph 48 or 49. There are other portions of that case which are quite relevant. At paragraph 44, and I'm paraphrasing, but
Don't paraphrase, just read verbatim.
the board needs to be satisfied that in its opinion, the proposed development would not, and I'm quoting, unduly interfere with the amenities of the neighborhood or materially interfere with or affect the use, enjoyment, or value of neighboring parcels of land. This aspect of the variance test, or some version of it, has existed in Alberta's planning legislation since 1977. So you can look at variance, but that portion of the test cannot be ignored. And on that note, there was also reference to the evidence and speculation about what could happen. Well, that was dealt with in the library board case as well. And in that regard, undue and material interference is a matter of degree that will depend on the specific facts of the individual case. And the SDAB has to consider if the proposed development would, rather than does, unduly interfere with the amenities of the neighborhood or materially interfere with, affect the use, not just the value, but the use and enjoyment of the neighboring lands. And I think it's important here to quote directly from that case with respect to that evidence. That's required because there was, of course, this, well, where they're just speculating, there's no evidence. Well, there is evidence in the form of a witness statement that's been sworn. And what was said in that case was, at paragraph 50, they stated, moreover, the legislature chose the conditional tense to describe the impact the appeal board must consider. The proposed development would not, as opposed to does not. This choice of language reflects that rarely will there be evidence of the actual effect of the proposed development on the amenities of the specific neighborhood or on the use, enjoyment, or value of the specific neighboring land. That is for a simple reason. When the issue arises, the developer is seeking a development permit for a development not yet in existence. In that sense, the development will be assessed prospectively, and the evidence on these negative effects will necessarily be future-oriented. It's future-oriented. It has to be speculation because it hasn't happened yet. They go on to say, as a result, the appeal board is entitled to infer, based on the evidentiary record, whether certain effects are likely to follow from the proposed development with the requested variance. So you as a board can consider what might happen. You have to, because it hasn't happened yet. And with that, we would submit that there is evidence as to what might happen and why it would unduly interfere with or materially interfere with the use and enjoyment of the neighboring lands and amenities.
So, with respect to my friend, Mr. Gunther, I submit to the board that he effectively danced around the primary issue in this case, which really boils down to a question of interpretation of the bylaw, and to a lesser degree, the scope, nature, and intent, but still relevant of City Council. Now, if this board, again, not bound by the decision, 2020 decision of the SDAB, but bound by the Alberta Court of Appeal decision in Library Board, does make a finding that this is to be characterized as a special event, and you've heard from us as to why we don't think that would be proper or reasonable. But if you do make that determination, we've heard from my friends that this is temporary and it's already January and all of these kind of things. Irrelevant for your consideration. Again, your consideration would be determined based on your interpretation of a special event and the fact that there is a definition in the bylaw that squarely applies to this type of facility that is not a permitted use in this zoning. But if in the unlikely event you find in favor of my friend, there has to be a further constraint. And the alternative argument would be that they're stuck with the 45 days, no additional time, no variance, and an additional constraint that we would suggest a limitation of 50 beds, no more, no less. Now, my friend, just so that we can correct the record as well, made reference to zoning and the applicability to the casino. Do you want to handle that, Riley?
Yeah, in that regard, reference to the fact that there's a casino in the industrial zone, well, the casino went through the proper avenues. Their property is rezoned. It's not an industrial zone anymore. I believe it's DC2, and forgive me, I don't have the extended definition of that, but a specific site, that's what it's zoned for. That's why it's permitted to be there. So we just wanted to correct that for the record.
And it's been like that for 25 plus years.
Anything further before I open it up for questions? No? Any questions? Mr. Peterson.
I hear that you want to restrict it to 50 beds should this go forward. What's the significance of reducing to 50 beds?
Well, first of all, I want to make sure this is that I'm very clear in terms of Pure's position that this is an alternative argument, and that in first instance this can't be permitted because it's not a special event. The significance of proposing the alternative argument is to limit things, number one, temporarily in accordance with the special event definition. We got to stick with 45 days. Number two, if we tie into the variance test or the materials test as been described by the courts, what we're trying to do is to limit the vulnerability and the impact to the adjacent businesses. Less people, less traffic, less risk, and as a corollary, less opportunity for conflict and business interruption. Heaven forbid, we've heard from my friends that, and I don't place any judgment or value on this statement, I'm just trying to repeat verbatim or the best as I can. We've got 10% of the shelter population who are problematic. Well, by virtue of limiting numbers, we limit and constrain risk as a corollary to that. Less people, less chances of people showing up at the casino doors, trying to obtain entry, and so on and so forth. So it's a ripple effect, board, I would suggest. And that could be constrained by limiting the time period temporarily to 45 days and limiting the number of people who could potentially have access and impact the casino's business and adjacent businesses in the area.
Anything more, Mr. Peterson?
No, thank you very much.
Thank you.
Seeing no other questions, we thank you for your presentation today. That will conclude the public portion of the hearing. The board will now deliberate in private and render its decision in writing in 15 days' time. We thank you all for appearing before us today, and we wish you a great rest of your day.
Thank you for your time and appreciate your efforts.